Hello and welcome to Chapter 2. We're going to be covering a topic that's a little difficult sometimes for students because this is a heavily procedural chapter. We're going to focus on some ideas that even for lawyers can be a little difficult to understand. So don't feel bad if the first time through this you don't understand, or if you need to pause this video and go back and take a look at what we're talking about. But we're going to talk about jurisdiction. And just to frame that quickly, jurisdiction is the authority of a court system to hear a case. And we're going to talk about the authority of a different court systems in the United States to hear the different cases that come up. We'll just skip through those learning objectives as usual. And let's start with the federal government. Now, most crimes are jurisdictionally handled by the states because they have the primary police power in the United States. The federal government, though, does prosecute people, and it does have the authority. It doesn't have inherent police power authority, so it has to act specific laws that have to be able to trace their authority back to the U.S. Constitution. And if you can't find a constitutional reason why Congress can pass the criminal law, then Congress doesn't have the authority. Most of the time, in fact all of the time in this regard probably, the way in which inherent police powers for the federal government are created, because they don't have them, so you have to make police powers, is via the Commerce Clause. And this is really a part of the Constitution that's used routinely to pass laws that impact us every day. So the power to regulate, and here's the quote, the commerce among the several states. You'll find that in Article 1 of the Constitution, and it handles most of the criminal law that the federal government passes, particularly most of what we'll talk about. And the way this works is that if there's multiple states involved, under the Commerce Clause, the federal government can regulate it. So a quick example so you can understand this. If I kidnapped someone in Wilmington, North Carolina, drove across the border to Myrtle Beach, South Carolina, since two states are involved, and believe it or not, kidnapping can be considered commerce, then the federal government can prosecute me for kidnapping, as well as, of course, the states of North Carolina and the states of South Carolina. An activity that is solely within one state, for example, local schools, is regulated jurisdictionally by those states and the local communities, but generally not the federal government. And sometimes we say if the federal government is trying to regulate something, they're overreaching. States and federal governments then have two separate criminal law jurisdictions. Now, when can you wind up in federal court? Well, if you take direct action against the federal government or its agencies. So if you use the U.S. mail to commit fraud, if you rob a bank which is secured by the Federal Deposit Insurance Corporation, if you assault an FBI agent, a DEA agent, an immigration agent, all of those would be offenses against federal officials. Or if the crime is beyond the jurisdiction of any state or between states. In other words, suppose it occurred outside of a state boundary, but still under the authority of the United States. An overseas military base might be an example there. Other federal jurisdictional powers, crimes that affect interstate or international travel or communication, crimes committed in places beyond the jurisdiction of any state, and that could be the District of Columbia, which is not a state, or on U.S.-controlled ships or aircraft, crimes that interfere with the activities of the federal government, such as, and I mentioned this before, the FDIC, the Federal Insured Savings and Loan Associations, if you committed tax fraud, if you tried to overthrow the U.S. government, all of those would create jurisdictional authority for the federal government. Now, what about probably the most common, the most serious common crime that we can talk about? That would be homicide. If I shot someone in downtown Raleigh, and I was a private citizen, and he was a private citizen, and I didn't shoot him because he was a member of the federal government, and I didn't shoot him and he wasn't employed by the federal government, and I wasn't in the military, it becomes difficult for the federal government to intervene in this murder. So only in certain situations, homicides, can the federal government get involved. Now, sometimes there's back doors to this, but if you are in a maritime or special territorial jurisdiction, so you're outside the state boundaries, but you're still within the U.S. Maritime District, which can be, it varies quite a bit. Traditionally, under traditional law, believe it or not, it started with how far a cannonball could fire from shore. And then it became a 3-mile, but then there can also be even more extensive zones for things like fishing and fishing violations, and it can be pretty far out to sea. When a death results from terrorism, sabotage, or reckless or negligent destruction of federal transportation facilities. That's interesting. We're going to talk about terrorism a little bit more as to what it is, but that's one way you can wind up being charged for murder by the federal government. If you killed a U.S. government official, so if you shot the president, if you killed a U.S. ambassador, that would be a federal crime. If you attack someone because they're performing a federal function, for example, you assaulted a postal official and you killed them, or an FBI agent, or a DEA agent. If the death occurs in connection with any federal crime, if you were committing tax fraud and you killed an investigator or an accountant, it's conceivable they could drag you in as a federal offense. If a homicide occurs during an offense defined by a Civil Rights Act of 1968, this is 42 U.S. Code, Section Civil Rights Act, Section 245. This is how I said they kind of back into things. Sometimes what we say is killing someone is the ultimate deprivation of civil rights. So sometimes if you kill someone, it violates their federal civil rights, so you can be tried by the federal government. This is sometimes used in cases where you see state officials act. They kill a U.S. citizen. That state doesn't prosecute, but the feds come in and do. Also, under the Comprehensive Crime Control Act of 1984, when an American citizen is killed anywhere in the world outside of the United States, the federal government claims that it can try people. What are some of the frequently used statutes that are used by the federal government? This is really beyond murder. Some of them could involve murder, to supplement state and local law enforcement. We have the Fugitive Felon Act, federal kidnapping, I kind of referred to that, federal conspiracy. Here's a big one, RICO, R-I-C-O, Racketeer Influence and Corrupt Organization Act. This was passed primarily against organized crime, but has really expanded in its use. If you committed a crime in a federal domain. Now, in North Carolina, there are areas of the state of North Carolina that are owned directly by the federal government. There can be national parks, things like that. The further out west you go, the more of America they own. So you get to some states like Nevada, where the vast majority of Nevada is federal land. Now, that doesn't mean there's buildings on it. It's by and large empty, but it can be things like grazing land, it can be national parks, it can just be wild areas. Federal Enclave Territories and Assimilated Crimes Act, and the expanding Federal Criminal Code, which in the past generation really has gotten bigger and bigger. All right, so what are federal enclaves? So, military installations. An example here in North Carolina, Fort Bragg, Camp Lejeune, Pope Air Force Base. All those bases, if you were to commit a crime on them, it's a federal enclave. Federal law applies. National parks and forests, federal law applies. Federal buildings, we've seen this with the protests in Portland, where federal response teams were sent in to deal with threats to federal courthouses and post offices. Also, and this opens up a huge can of worms, reservations. Nation-to-nation jurisdiction. Now, the law of a nation follows its ships and its aircraft. So, as you, if a plane is flying and it's over the Atlantic, until it lands, if you were to commit a crime on board a U.S. ship or U.S. plane, you would be subject to the jurisdiction of the United States government. We also, since the 1980s, have created extraordinary rendition. And that's the practice of seizing foreign nationals in one country and bringing them to another for questioning or prosecution or permanent detention. So the U.S. has joined other nations to define certain offenses as against the law of nations and international treaties. Now, when your book was being published, it included this slide where it said the International Court of Criminal Justice was the first permanent war crimes court, and it was created in 2002. And it was initially seen as a mechanism to deal with international crimes. The problem is what happens when this international court wants to look at behavior of Americans. It traditionally was fine with the United States when it was being used to deal with foreigners, but when it started to be dealt with Americans, it caused a lot of problems. So the U.S. traditionally cooperated with the ICC, but in 2018, President Trump withdrew all support for it. One of the reasons for this is that there were reports that the ICC was going to investigate American military behavior in Afghanistan. And they claimed they had authority to do so, just like the ICC had authority to investigate war crimes in places like Liberia or Ethiopia or Darfur or Libya. But the difference here was that we were involved. So the president said, not going to happen. We are going to block any investigation of U.S. citizens, particularly U.S. military. And they actively sanctioned the court. They actually went after people on the court, denying them visas and restricting them. Basically, the United States won't let our citizens be impacted by the court, although we wanted to use it on foreign citizens. Final point to consider about jurisdiction is extradition. Extradition is the removal of a person from one jurisdiction to another so they can face charges. Now, typically what happens is the United States signs treaties with different countries to extradite criminals. And it's fairly technical as to how this is done. And we don't have extradition treaties with every country. We don't have them, for example, with Afghanistan. That's a big one. We don't have it with a surprising number of countries. We have them with some that we are unsurprising, but We don't have extradition treaties with Iran, for example, Syria, North Korea, Bhutan. Well, that's not a big surprise. There's also certain countries that we don't really recognize. We have diplomatic relations with several countries like Kuwait, Lebanon, Laos, Russia, but we don't have extradition treaties from them. So Mr. Snowden, who fled to Russia eventually, we would love to get him back because he disclosed confidential information about a CIA program, but the Russians won't turn him over, saying no extradition treaty. Rendition in the war on terror. Another thing that's done here jurisdictionally is extraordinary rendition. And this is when you seize a foreign national in one country, transport them to a second country for questioning or prosecution. Now, here we have a bit of an issue. It is outside the technical legal process. And what can happen is several countries basically will do things that would be illegal for us to do. So extraordinary rendition can be kidnapping a citizen or a citizen, say, of Somalia, transporting him to Poland, and have him tortured in Poland for information we want. That's extraordinary rendition. This actually began all the way back in 1987 under Ronald Reagan. The problem here is the United Nations considers much of this a crime against humanity. So they're kind of powerless to do anything to the United States because we sit on the Security Council and we can block any sort of resolutions, and we basically will ignore the UN when we don't like what it's doing. Okay, what about military-related crimes? A person who enters the U.S. military comes subject to a unique set of rules. These are called the Uniform Code of Military Justice. And if you commit a crime while you are a member of the military, whether you are on base or off base, you are subject to the Uniform Code of Military Justice. However, if a civilian comes onto a U.S. military base and commits a crime, the trial is not held by the military. It may be a federal trial, but it's not going to be held by the military. Now, certain civilians who work with military units, and this is where it can get pretty vague, can be subject in certain circumstances to the Code of Military Justice. And this raises the very thorny issue of terrorists, too. Non-citizen terrorists seized by the military can be tried and detained by the military. Non-citizen enemy combatants can be held by the military. Enemy combatants who are U.S. citizens are, in theory, and I want to emphasize that, in theory, entitled to trials in federal courts. This is a huge can of worms because first of all, who gets to define what a terrorist is? What evidence becomes admissible? And when I say non-citizen enemy combatants may be held by the U.S. military, how long can they hold them for? What's the limit on trials? We have people in Guantanamo that we've basically said, we're going to hold these people probably forever, but we can't give them trials. And, that really is a kind of a radical break with 500 years of judicial process in the United States. In theory, you have also what's called indefinite detention. This is Section 412 of the U.S. Patriot Act. And that says if you're not a U.S. citizen or if you're an immigrant, in theory we can detain you. And this is in theory forever. You're probably saying, well, this doesn't happen. But you should read the case of Jose Padilla, who was a U.S. citizen. Now, he was arrested in Chicago in 2002. Initially, he wasn't charged with a crime. He was held in a U.S. military brig, I believe in South Carolina. as a material witness. And eventually they changed it to, nope, he is an enemy combatant. And he was held for 3.5 years without trial. And during this period, he claimed, and there's some evidence to support this, that he was tortured. Eventually he was tried, although he seemed to, at this point, be suffering from mental illness because much of his time was spent in solitary confinement, and eventually he was convicted. He served, I want to say, I think he's still serving, if I'm not mistaken. He was initially sentenced to, I think, 17 years, and he got 21. The courts, when he said, well, look, the military had me and was torturing me, they've really said that there's jurisdictional issues and we can't really hear the cases, and it's kind of from a lawyer's point of view, it's kind of a frightening idea. And really the courts, up until the Supreme Court of the United States actually heard an appeal. You can read that case. It's, I believe it's called Rumsfeld versus Padilla. And the Supreme Court actually declined to hear it. It was refiled. It went back up again. It went to the District Court for South Carolina. There was it's really a very twisted process, this indefinite detention. Okay, what about Indian tribes? What are their jurisdictions? Well, in theory, Native American reservations are sovereign nations. They are kind of mini states like North Carolina, and they have the right to regulate themselves. Major crimes for certain things, are removed to federal courts. Crimes by non-Indians are outside the jurisdiction of tribal courts, but Native Americans who commit crimes, whether they're inside or outside Indian country, which means a reservation, are subject to the laws of the state or the government where the crime was committed. Tribal courts are today pretty limited, usually to misdemeanors or minor crimes. However, you have seen some wiggle room of increase there. And there's really a lot of litigation going on about Indian, and it's referred to as Indian, not Native American most of the time, Indian tribes and jurisdictions. It's very complex. Okay, a couple thinking points here at the end of this chapter. One is you should go ahead and look at Roman Polanski, who's a very famous director who was accused of statutory rape, drugging and raping a 13-year-old girl. He pled guilty to lesser charges but fled to France before he was actually sentenced. He was eventually taken into custody by the Swiss, and he wound up in Poland. It's a very convoluted story again, but it's a good example of how complex international extradition can be. You also have, this is kind of a fun case to read in some ways, you have what's called the April 1st, 2010 incident, which is when some pirates were dumb enough to attack a U.S. Navy ship. And as you can imagine, pirate vessels operating off of Somalia attacked, I think it was the USS Nicholas was listed here, but I thought it was also the Farragut, but I might be mistaken. Maybe she was the flagship, but the Nicholas, I know, after it was attacked by this small skiff off the coast of Kenya, returned fire, disabled the pirates, got them to surrender, brought them into custody. The captured pirates were then flown to Virginia and tried. They were found guilty in Virginia, and they got life sentences. As far as I know, they're still in prison. It's pretty interesting. Interesting case, at least. And there's a link to it on YouTube. Final one to talk about here is Robert Bales, who, while serving in the military in Afghanistan, seemed to suffer some sort of psychotic break, I would argue, but he was, he went out of his unit, and he went a killing spree. There's no other way to say it. He killed, I think, 16 Afghan civilians in Kandahar province. This was in 2012. And he was tried in the United States, even though he committed this crime in Afghanistan. He was eventually sentenced to life here. The Afghans were kind of outraged. They wanted him. And, one of the questions you can ask is, well, what do you think about this outcome? Should Bales have been tried in Afghanistan by the Afghanis? Should he have been tried by the Americans in America? These are all valid points. Okay, well, I know this is complex. I know we covered a lot of things here. I hope I can make it a little bit clearer when we get together for our lecture. Other than that, have a good night, everybody.